Today we are going to talk about the Supreme Court term the quarter, because most of the people they think that Supreme Court cases are just for the lawyers in the ropes and the long kicks. But this past term's ruling just quietly rewired how you work, how you speak, and even what's legal online. And almost just nobody noticed. And we are not talking about the headline grabbers. So we are talking about five under the radar cases that are already changing your everyday life. And think of it as just a decoder briefing, so not as a civic lecture. And we're about to break down just what really happened in the Supreme Court and what it means for you, and why no one is talking about it, and who is quietly wins or loses just from each decision. And there will be like no fluff, no legalist lecture, just juicy, just eye-opening stuff, the kind even just the lawyers might have missed. So let's dive in. We will start with workplace shakeup. It's like Muldrow with the city of Louis, and with the point of a free speech at work. First of all, we will try to imagine for a moment. So, like, you've been a star employee in a specific, just special unit at work, and gig with prestige, perks, maybe even just a marked take-home car, and then a new boss comes in and then the proof. So you're reassigned to a more just a mundane job, like a same day, same pay, same title, but all the cool just parts of your job vanish. Why? So in this case of just Jatonia Muldrow, so a police sergeant in St. Louis, so she suspected. So it was because she's a woman, and her new commander just literally wanted to replace her with a man, and she lost her special just intel role, so her flexible schedule, her take-home vehicle, and basically all the just intangible that everything that makes her job just awesome. And even though her salary just stayed the same, and she sued for sex discrimination just under Title VII and civil rights. And here is the catch. So for decades, many courts would shrug to say, so, hey, you didn't just get demoted or lose pay, so no harm, no foul. And in the legal jargon, so your transfer wasn't a materially just adverse action. So your case got too stout. And then, when the times come, like now, it was in the Supreme Court in just Muldrow with the city of St. Louis. And just to flip the script for a workplace nationwide. And in April 2024, so the court ruled that Title VII bars employers from discriminating even in decisions like lateral transfers. Yeah, so there were like no economical damages, and so like without the employee just having to prove some significant disadvantage. So in plain English, if if the move was motivated by race, sex, or other just protected traits, it's not necessary. It's not just required from you just to prove that there were like specific economical damages. So it's a legal discrimination, like period, and no other things are required just to prove it to have like a valid claims. But more letting just their bosses, so they are like higher departments just off the hook just because they were just sneaky enough just to keep your pay the same. And this is a huge deal. So it means that all those subtle workplace punishments, so like the dead end reassignments, like the plucking of the prime project and the shift that nobody wants, are now inactionable. So if driven by bias. And you may have a question. So why is no one is talking about it? Well, so it doesn't have to the flash of the just a free speech or abortion case, but it flew under the radar while just the bigger news stole the spotlight. But for anyone with a job, so that's most of us, this ruling is quietly just wrote the rules. It strengthens those the employees' just rights in a way that even the many attorneys didn't expect. So for years, courts had raised the bar unrealistically high for discrimination claims, where you have to prove the specific economical damages or just the mental health damages. So, and that led a lot of justices slide. So especially those soft retaliation or bias move that didn't just come with a pay cut, but no longer from now. And the Supreme Court basically told the lower courts, so like, stop adding extra hurdles that aren't just in the law. So Title VII's text says that you can't just discriminate in terms of conditions or just the privileges of employment. It doesn't say only if the victim just loses money or has some kind of embarrassment. And what this actually means for you. So if you get just reassigned, passed over, or otherwise just mistreated at work because of the protected characteristics like race, sex, religion, so you now have a clear path to justice. So you don't have to prove that discrimination also cost you a promotion or a pile of cash. Discrimination is a harm. So maybe you're transferred of the client account, so you build because you're just the wrong and just ethnicity for the new boss taste, or your schedule gets yanked around just because you're pregnant. And these moves used to be just too minor just to sue over in some courts, because they're not just raising the height and bar, so it's going to be dismissed procedurally. But now those days are over. And it's a quiet revolution in employment law. It's like quiet winners. Who are they? Obviously, so employees who face a subtle bias or retaliation. So they just gain the leverage to hold employers accountable. And who are the quiet losers? Employers and their lawyers who used to get the cases thrown just out on technicalities like no material harm, and they are going to have a harder time now. And in fact, so the business lobby and some conservative groups try to spin this ruling as a threat, and just bizarrely claiming it could just endanger workplace diversity programs. And there were like many spoilers that that's a nonsense, and it actually just stops bad actors from hiding behind the loopholes. And and here is the ironic twist. So this pro-worker outcome came from a court often labeled as a pro-business. So even the conservative justice just signed onto the just textualist and no-nonsense reading of the law. And it turns out that following the text of a civil rights statute can lead to a progressive result. And most people, even most attorneys, didn't even see that coming. So next time you hear someone is a gripe that the Supreme Court only sides with the big guys over little guys, so tell them about Multro. So it's now easier for the little guy or gal at work to speak up and get their day in the court. Even in injustice was more just subtle than a firing or a pay cut. And that's a real life, like free speech at work. And the freedom to call out discrimination empowered by ensuring the Supreme Court decision. And yeah, so that's a Muldrow with the city of St. Louis. So like no protests, no viral headlines, no speeches on courthouse steps. Just a client, a technic shift just under the floor of the very HR department in America, which is wild. So like everyone is just doom scrolling through political dramas. The Supreme Court just slipped a new just line into the social contract. So now you don't have to lose money to lose fairness. And by the way, so then we have like official twists, personal fields like linked with the free like social media with government, and we will start with a question. So have you ever been commented on your mayor's Facebook post or replied to a tweet by a city official, and what if they hit that block button on you, and is that censorship by the government or just a personal squabble? And in an age where politicians communicate via memes 280 character blasts, and Supreme Court had to answer a very modern question. So when is a public official social media account, so like the government, and when it's just them being themselves? And when we are entering Linke with Fried, James Fried, city manager of a port here in like Michigan, used his Facebook page to talk about city affairs, things like COVID-19 updates, and one local resident named as a Kevin linked like kept posting critical comments. So you can guess what happened next. So Fried deleted LinkedIn's account, comments, and blocked him. And Linke just cried fool. So First Amendment violation. And he argued that Fried's Facebook page was effectively a public forum just run by a government official. So like putting him was unconstitutional censorship. And the Supreme Court's unanimous decision in March 2024 just gave us a new rule for a digital age. So from now, a public official social media activity just counts as a separate action, and thus is constrained by the First Amendment, and only if two things are true. First, so like it should be like the official has the governmental just authority to do what they are doing on that account, and the second is that they're actually using the account as part of their job. And in plainer terms, so the justice said that not every tweet by a mayor is an official decree. So to sue them for censorship, so you got to show they were acting in an official capacity on the social media page. And if an official is just shooting, so the breeze or posting personal opinions on a page they labeled as a private, they can block whoever they want. But if they are running an account to do city business, posting official just announcement and soliciting citizen input on a public policy, so they better not ban people just for criticizing or else. So like they are violating the First Amendment. So how do you tell the difference? So the court offered some practical clues, like content and context are key. And like, is a post context something that the official is tasked with doing as a part of their job? Like, for example, if a public health officer uses a Facebook to post a restaurant health code violations that just looks official, just assuming a health, just a public health in their portfolio, and if a city just some council member and posts about their favorable just like local restaurants, so with no official tie-in, so that's a in personal territory. And the courts even noted that the markers like calling it a Mayor Jane Doe like official page with a Jane Doe personal page, and they're using disclaimers, so views my own. So creating have a presumption like the page is a personal. And Linke Fried had preserved his page as a personal and mixed in a lot of just a non-official context. So the court found that his blocking spree was not a state action. So Linke's lawsuit was essentially just a DOA, and because Fried just wasn't acting as a government official when he blocked him. So he was just another Facebook user just creating his feed. And this ruling is a big for anyone who interacts with the government on social media, which is to say, so pretty much everybody, just everyone on the internet. And what it means for you, so basically, if you are being kicked off of a politician's or public official page, so like your ability to challenge that now hinges on whether so that page is actually just an arm of the government or just the official's soapbox. And the Supreme Court basically said, so we're not going to treat every social media quarrel with an official as just a constitutional crisis. And only when the official is using this page as a part of their job, so like do First Amendment rules kick in. And so if your government just has a personal Twitter, so where she mostly tweets about your kids or sports and occasionally mentions work, she can likely block trolls with impunity. But if she has an official governor account posting the policy updates, deleting critical comments, and so there could be like a land here in illegal hot water. And And you may have a question, so why is no one is talking about this? Well, it just didn't make a blip in legal circles, but the concept of state action on Twitter, so it's not just actually a headline grabber, so for average person, and still, so behind the scenes, so you can bet city attorneys and the social media managers for the public officials and just writing their playbook. So the court basically warned officials. So if you mix official business into your personal page and then block someone, so you're making on this eye. So like the safe play is to keep the accounts like separate, so one official, one personal, and which is exactly so what many are doing if they weren't just already. Obviously, so the quiet winners are the government officials and the politicians just who want to manage their online presence, and they have clear rules of the road now. So like they can still have a personal spaces online, so where they can just filter out just hecklers as long as they are just aren't using those spaces for actual governing. And in some words, a mayor can have a personal Instagram for family photos, so like block away and separate from the official city. So like Facebook page. So hands on of the ban button there. And another winner, so like obviously as a principle of a free speech. So like oddly enough, so by drawing a clear line, so the court actually helped ensure that truly official channels remain open forums. So while private chatters remains private, and who are the quiet losers? Like citizens who assumed that any social media account of an official just was a fair game for just an open debate. And if an official is a savvy and labels their page personal, so your First Amendment lawsuit for being blocked will likely get nowhere. And also, officials who were sloppy about blurring personal and official online, so they are on notice to straighten up or risk liability. Of course, so like one more thing, not just widely know, like the Supreme Court decided linked alongside a similar case so about school board members like O'Connor, Ratsif with Gardner, and in that instance, the officials had the Facebook pages, so that were closely just tied to their roles, and posting about the school board matters and just incessantly, and they blocked some parents, and the court sent that case back to apply the new test and strongly just hinting that those trustees were acting as officials and thus may have violated the First Amendment by blocking its critics. And in short, so whether you can be blocked by your government online, so now boils down to a factual analysis. So like, was that official wearing their government hat on that account or not? And it's a nuanced rule for nuanced problem, but now everything that is just barely like going through, like you can make a news, but but this thing will quietly affect so like how politicians interact with constituents and in the digital public square, and now so like the most people powerful, like in your own town, and you can like basically circulate and curate just reality with a click, and the same officials who swore on an oath to transparency like can hit the block like a bouncer at a bar, and it's technically legal as long as they are just doing it personally, and this is one is big. So like though you wouldn't just know if from the nightly news it's about wonky legal doctrine. So but strap in, so because it's fundamentally about how about who has the power to make the rules that we all live by. So do you remember like ever just hearing the phrase like chevron deference and like back in school? Probably not. So because most people don't. But for the last 40 years, so it's been a cornerstone of how the government worked. And as of June 28, 2024, it's gone. And And Chevron deference from 1984 case like Chevron USA with NRDC was a rule that said, so like when a law is ambiguous, courts should defer to the interpretation uh, of the expert like agency like charged with enforcing that law. And as long as interpretation is reasonable in practice, so it meant that agencies like EPA, FDA, OSHA, etc., so had the wiggle room to interpret the veg statutes, and the judges would usually go, yeah, so they are just experts like that. So let's go with their call, and that's how we got lots of more than regs and by agencies, so like filings and the blanks Congress left. So whether you think like that's good, like flexible, expert-driven policy, or a bad, like unaccountable bureaucratics that are making rules, that was the system. And there was like an interesting case about no just about the same issue like Luper Bright Enterprises with Raimondo. So that case was a case that brought a loaded question to the Supreme Court: should Chevron be overturned? And the case itself was about something pretty specific. A group of commercial fishermen, just Luper Bright and the friends, objecting to a national marine, so like a fishery service rule that made just them pay for monitors on their fishing boats. And they said, "Hey, Congress, they never said so we have to pay out of pockets for this," and the agency just decided it's on its own. And the lower courts, bound by Chevron, Shirachi, and said, so the law is ambiguous and the agency is reading it's reasonable, so you lose. And the fishermen appealed to the Supremes not just on their rule, but to kill the entire like Chevron doctrine that shuts them down. And they did it in a 6-3 decision with a Justice Jackson recused. So the Supreme Court overruled the Chevron doctrine oversight like outright, and it's hard to overstate that this a 40-year-old precedent that permitted thousands of cases now has a history. And Chief Justice Roberts led the majority declaring that courts, though not agencies, have their sole like power to say, what the law is. And in other words, judges shouldn't be just a rubber stamping agencies in the interpretations anymore. So if a Congress wrote a federal law and the ambiguity is not just an implicit blank, so like a blank check to the agency to decide, so it's instead the court must independently figure it out what the law means, unless the Congress explicitly gave the agency the power to make rules on the topic. And ambiguity no longer automatically equals agency win. And for those of us not glued to administrative law blocks, so here what this means for you, like basically, we will try to summarize. So the balance of power in some regulatory matters just tidaled away from expert agencies and towards the courts, and by extension, so the businesses or individuals challenging those regulations. And so like think about any federal regulation, so your counter, so maybe they build agencies like standard for your car or safety rules at your workplace or pollution limits for the water you drink, and even rules about internet privacy. All those likely involve agencies interpreting statutes. And without Chevron, it just got easier for companies to challenge those rules in court and harder for the agencies to defend them. And the court basically opened the floodgates for what one law firm called a significant uptick to a new lawsuit challenging agency regulations and across sectors. And industries that left hemmed in by aggressive regulations are licking their chops. So they see opportunity. And environmental regs, labor protections, financial rules, so you name it, could be on the chopping block if challenges convince judges that agencies went beyond the strict reading of the law. So why isn't everyone talking about this? Frankly, the Chevron deference sounds like a dry, inside baseball lawyer talk. So it's a complex, and it doesn't have the visceral appeal of say, a gun rights battle or a free speech showdown. But in some ways, so it's more important than either. So the decision affects the air you breathe and the water you drink and the safety of the workplace, to the stability of your bank, and literally so nuts and the bolts of daily lives that are governed by the regs. And Justice Kagan, in a scathing dissent, warned that the court conservative just majority had just turned itself into the country of administrative czar, like grabbing power from agencies to decide a complex policy question from the bench. So she noted that for decades, Chevron allowed federal experts to make calls on intricate scientific and technical questions like environmental protection, food and drug safety, so you name it. And within the board limits set by Congress, now six justices effectively told those experts, like, step aside, we're judges, we will just handle it from here. And the Kagan didn't mean just words, like a rule of judicial community and humility gives away to rule of judicial just hubris. So she wrote that calling out the majority for a blatant power grab, and that was insane. So obviously, the quiet winners are the regulated businesses and industry groups. So they just got a potent, like a new weapon to fight regulations they don't like. And even agency rule costs and just industry money, so you can bet a lawsuit is coming. So like arguing the agency to stretch to the law beyond what Congress clearly allowed, and the companies no longer have to hear like sorry, the statute's ambiguous and the agencies get deference. So instead, they will say the statute's ambiguous, so that the court should strike the rules unless the agency's just interpretation is not just unreasonable, but the best reading. Like also, any officials who philosophically just oppose administrative state are winners. So this was a long sought victory for them, like overturning this Chevron. So like has been on conservative legal wish list for years. And the quiet losers. Who are the quiet losers? Obviously, like federal agencies, obviously EPA, OSHA, FTC. So you name it. They just lost a huge chunk of their authority, so they now operate under the threat, so that any nuclear law they implement will be a second guessed without a deference. And if you believe that robust regulations are necessary just to protect consumers, workers, or the environment, then the public who benefits from those protections could be on the losing side too. And in short terms, like nothing drastic happens overnight. So the court didn't toss out existing rules in massive but the next time those rules get amended or challenged, so the agencies can't just fall back on the Chevron. So let us do this. And it's open to litigate, so the exact meaning of every word Congress wrote. Obviously, so we've got like one more wrinkle. So the court didn't leave a very clear placement standards. So they basically said, courts just do your normal statutory interpretations. So they acknowledge that sometimes the Congress does delegate a power explicitly in those cases, and even agencies is just acting within that zone. And presumably, so it's a rules stand. And the court noted to the idea that the best reading of some laws is that the agencies have a discretion. And also they didn't judge something like a called Skidmore deference, so which is a weaker version, so where an agency, well, just a reasoned opinion can be persuasive but not binding. So agencies aren't entirely ignored. And if they make a strong case, a court might adopt their view, but the age of agency knows best is done. So now it's like a judge knows best. And for for a real world analogy, so like think of a referee, like the agency who was given a leeway to interpret the rules of the game, and the Supreme Court just said, so no, we are going to check every call with instant replay and make our own call. And to some, that's keeping the refs honest and enforcing the true rules. To others, it means a game about to slow, just a growl, and the folks in the skybox, or the judges, with no one field expertise, so are recalling balls and strikes, and whether just a freedom or a chaos is very much up for a debate. But now you know the quiet Supreme Court ruling that just shifted to a ton of power in Washington, and outside of the legal circles, almost nobody realizes it yet. So let's switch gears from wonky regulations to something far more visceral, like guns and domestic violence. And if you or someone you know has ever had to get a restraining order against an abusive partner, so this is one hits close, like to home. And it asks chilling questions. So can the government disarm someone who is subject to a domestic violence and restraining order? And for years, the answer was clearly yes. So, like, a federal law has banned such individuals from possessing guns since 1994. But shockwave from a recent Supreme Court ruling. So, like, the in 2024, like Bruin case put that in doubt, and one lower court actually said no, you can't disarm them. The term the Supreme Court essentially had to put out a fire it arguably started. And the case is United States with Rahimi. Zaki Rahimi was, to put it mildly, so like a dangerous man. And he had a civil protective order against him from allegedly just abusing his ex-girlfriend. And despite that, he went on a violent fear, so like involving in 5 shootings in a few months, including firing AR-15 into someone's house and shooting at a driver just after a car incident. And when the police searched his home, they found a gun, surprise, and hauled him up on the federal charge of possessing a firearm just while under a domestic violence restraining order, and open and shut, like one would think. But here is where constitutional law appended to common sense, like the Fifth Circuit Court of the Appeals tossed out Rahimi's gun charge, saying that the law that disarmed him violated the Second Amendment. Why? So because the Supreme Court of New York, like state rifle with and the pistol as the Bruin decision in 2024, in 2022 in the Bruin, and the Supreme Court announced that a new test for gun laws. So you have to look to history. And if there is no historical tradition from the 18th or 19th century of a particular just gun restriction, so then that law today is just presumptively unconstitutional. And the Fifth Circuit applied that the test in a head scratching way. So they said we don't recall any just founding era law that basically banned domestic abusers from having guns and things. Frankly, domestic violence wasn't just even a legal concept back then. So this 1994 law must go. And they treated the lack of an exact historical twist as a proof. So the law didn't fit Americans' gun tradition. And fast forward to June 2024, the Supreme Court in an 8-1 decision reversed the Fifth Circuit and upheld the law that keeps a gun out just of the hands of domestic abusers. And in doing so, as the court refines that history test from a Bruin, and they effectively said, so we are not looking for a one-to-one historical match, but rather just general analogs. And if historically there were laws keeping guns from people deemed dangerous, that can be enough of a parallel. And indeed, the government pointed to old practices like like surety of the peace laws, so where someone accused of being a violent or a threat could be required by a court to post a bond or just else and be disarmed. And those aren't just exactly the same as a more than severe restraining order, but they show a principle. As the founders and their successors didn't let the dangerous individuals kept weapons freely. And the Supreme Court brought the argument, and the majority opinion, written by Chief Justice Roberts, basically concluded that when someone has been founded by a court to pose a credible threat to an intimate partner and temporarily disarming them in line so with the Second Amendment history and basically a tradition. And for everyday people, so what this means is a straightforward. Like if you have a restraining order or let's say against someone for abuse, like a federal law still backs you up, but that person cannot have a gun, and that's constitutional. So likewise, if you're under such an order, and we hope to God not, you cannot possess a firearm lawfully. So the Supreme Court decision will save lives by keeping this law intact, and it also slams so the brackets and at least just slightly on the runway, so like trains the Bruin set in motion. And after Bruin, so lower courts have casting doubts on all courts of gun regulations, and not just this one, but also just laws on the fellows and the firearms, just the age limits. And by saying so, we don't see an exact like 1791 analog. And in Rahimi, so the Supreme Court sent a signal, so be more nuanced with history. And they emphasized using that analogs and just a general principle rather than just strict matches. And when comparing modern laws to historical tradition, so that's a lawyer speak, but it means that judges shouldn't just strike down the lawsuit just because it isn't just a carbon copied from a flintlock musket era. And why isn't just everyone is talking about this? So on one hand, guns are always just to get attention, but many media outlets didn't know this outcome. But it might just not have just a golden sustained coverage because ultimately it's also the Supreme Court upheld the gun restriction and maintaining to status quo rather than just retreating something down. And in today's polarized news environment, the Supreme Court doesn't just rock and bolt on a gun law, so isn't the sexiest headline, but the important is a huge. And this was a test of how far the court's Second Amendment revolution would go. So the answer for now is that even the conservative majority court has its limits. So they drew the line at arming domestic abusers, relief to many. And interestingly, so the decision was 8-1, with Justice Thomas DeLone dissenting. And Thomas wanted to stick to the pure, strict historical test he articulated in the Bruin, and is seemingly just untroubled by the real-world carnage and the stake, and the fact that even Justice Alito and Barrett, so like very pro to A, typically sided with the majority. So here, that tells you that something. So the optics and implications of the striking this law were too dreadful. And the court may be ideologically just a pro-gun, but they are not blind to the consequences of radical decisions on this area. So it would have been just a PR and a human safety nightmare, but that's how it is. So who are the winners, quiet winners? So they are the victims of domestic violence and those who advocate for them. Their safety net and ability of courts to keep guns away from no abusers and remains intact. So like also law enforcement and prosecutors who argue that this law is crucial for preventing violent escalators, so like one big more supply, like moderate conservatives on the court, so like Roberts and Kanapagach like score to win and tempting like in the Bruin doctrine, so to be more practical. And this showed that the court can uphold some guns regulations opposed Bruin. And The quiet losers, like the most absolute gun rights, like proponents, and those were just who were hoping Hebron would mean virtually any modern gun law falls. And they got a reality check, and of course, so Mr. Rahimi himself, so calling him a quiet loser is a generous. So his case is high profile, and by all accounts, he is not just someone you would want armed. And one could also say that the Fifth Circuit's approach lost, and that could get rebuked from reading just a Brown in an overly rigid way. But beyond domestic violence, so the Rahimi decision leaves some open questions. So, like the court didn't just list out which other guns laws are safe, but by embracing broader historic analogs, so they implied that laws keeping guns from dangerous folks like felons or those with mental illnesses might likewise be upheld, so like using the same logic. And we will see those fights in the coming years, but the decoder here is like the Supreme Court is not a carte blanche anti-regulation on guns, so they opened the door with a broom, but Rahimi showed that they are closing it partway when necessary to avoid the real harm. And it's a quiet course of correction that many outside those legal world might have missed while focusing on the harder, just the culture war topics. And and just finally, so like let's let's maybe pick up something like different from the topics that we are just outlined. So like something that is more related to the internet speech battle and the war on the big tech censorship. Like let's talk about the wild web and who gets to control what you see or say on the social media. So basically, you might recall a few years old back when people were arguing what that Facebook, Twitter, YouTube were censoring certain viewpoints, especially just conservative votes and those voices, and some states decided to do something about it. As a result, like laws in Texas and Florida that try to stop large social media platforms from moderating content based on a viewpoint. And essentially, so Texas law, often called HB 20, said if a social platform has millions of users, it cannot ban or downrank content like just because of the user's viewpoint. It was aimed at forcing platforms to halt speech that the companies might otherwise remove. And this extremist rhetoric, hate speech, misinformation, as long as it wasn't just otherwise illegal. So Florida's law was similar with some differences and aiming to punish just the platforms that allegedly discriminate against a conservative speech. And it sounds like a First Amendment issue. So like ding ding, so you're right, but whose First Amendment? The people who want to post or the platforms that want to moderate, and this turned into a legal cage watch. Like a net choice, an industry group representing the tech companies and all those youth boss states, like saying these laws violate the First Amendment rights of the platforms. And yes, so corporations have speech rights too, the right to decide what content to publish or not publish. And on the other side, the states argued they were protecting users' free speech from Silicon Valley's supposed bias. And lower courts split on these laws. So the Florida law was largely blocked by the 11th Circuit, so they sided with the platforms, but the Fifth Circuit shockingly upheld so the Texas law and basically just defines the argument that social media companies could be treated like common carriers, so with no right to kick off users. And this split all but begged for Supreme Court intervention. And in a net choice with Paxton like consolidated with Modi with the next choice for the Florida part, like a multi-count, and the court took up those issues. So the decision came down at the very end of June 2024, and it was a huge win for a big tech and a defeat for a state attempts to control online speech. And here is what the Supreme Court did. Like basically they vacated the lower court's ruling and sent the cases back down, but not without dropping same like very clear First Amendment wisdom along the way. And Justice Kagan, interestingly, so one of the more just a liberal justice, wrote the opinion to the court. And she didn't just mention words about these state laws. So the court held the First Amendment protest, a private entity's decision to curate content. And they called the Texas and the Florida laws exactly so what their critics said they were like government control over private speech, and that so there are few greater dangers to a free expression than just letting the government commander so like the editorial decisions of private actors. And in one PT line, so the court said when a state tells a website, so you must carry the speech you disagree with. And it's basically like forcing the site to alter its own expression, so which is just unconstitutional. And the majority compared social media platforms to content moderation to decisions of newspaper editors or parade organizers, so inherently just expressive choices and about what speech to include or exclude. And the government cannot just dictate those choices. And that's a valid point. And they also hammered like home a point, so you might not like how platforms moderate, so you might think they are biased, but it's no job for a government to decide what counts as a right balance of speech on a private platform. And in other choice, so the cure of a government intervention in worse than the disease of a private censorship. And Justice Barrett so wrote a concurrence underscoring that yes, corporations do have a First Amendment rights, and in case anyone doubted. And the upshot is that the court, just the reasoning leaves very little room for states to tinker with the content moderation rules, and didn't just outright strike down the laws with a final judgment. And procedurally, so they wanted to allow our courts to do some further fact-finding, but practically, so the writing is on the wall. So this social media must carry laws are on a life support, and the First Amendment is pulling the plug. And basically, like, what this means for you. And first of all, and second of all, like the experience of using social media is not going to suddenly just to become free for all, where like anything goes by government decree. Like platforms will retain the power to ban trolls, hate speech, and perverse like any disinformation that super readers as a sip it. And if you get banned on Twitter or X for calling someone a nasty name or get demonetized on YouTube for extreme content, so you can't just run on your state capital and expect a law force your to reinstate you. So like, and the second is that conversely, if you feel a big tech unfairly muzzle certain viewpoints, this was a major blow to that cause. At least like via government action. So the Supreme Court basically said that the remedy for a bias in private platforms is a marked and user pressure. So not like legal mandates compelling neutrality. And why isn't just everyone talking about this? Maybe because in part this ruling came amid a flurry of other just big decisions it dropped right as turn ended. So when the news was buzzing about other cases, and also so while it's a hot button issue, it's relatively just a new and somewhat abstract. So many people don't yet understand or care about the Section 230S and the common carrier so analogies. But let's be real, this affects information ecosystem. So we all live in. Think about the last election circle, like the misinformation debates and the cries of Facebook censored me or Twitter shadow banned me. Like the Supreme Court has basically cast its vote in that debate on the side of the platform's right to curate. And they are treating social media companies not like public utilities, but the private publishers with a right to editorial judgment. and that's a huge. So who are the quiet winners? Obviously, so like big tech, Facebook, Google, X, and their autonomy just over their platforms is vindicated as the highest level. And also, like arguably, users who prefer curated spaces. If you don't want your Facebook feed joining into a chain, so you can present sign of just relief that states can't just pull those platform moderates, the moderation policies. So free speech purists in the just a classical sense also won, and the court stance is that more free speech. So like the platforms owns free speech rights, and Trump misconceived like a fairness doctrine for the internet, and quiet losers again as a government of Texas, Florida, and other states like itching to regulate social media content, and their legal theory got smacked down. And those who feel disenfranchised by social media moderation, certain just political groups who felt targeted, lost, or a potential just a tool to fight back, and they might call it a loss for free speech, but the court's view is that greater free speech principle is keeping government out of the content policy business. And it's also just worth noting that the interesting coalition in this ruling, so it wasn't just your usual 6-3 conservative with a liberal split. Like Kagan is a liberal, wrote it like joined by a mix that included conservatives and the liberals. And that part suggests that when it comes to the First Amendment, strange bedfellows can emerge. And defending the free speech of an internet corporations against the government over issues like appeal to enough justices across ideological lines. And this underscores a pattern. This term, the court repeatedly favors individual and private entity rights over government control. And here it was a corporate editorial like freedom over state regulation, and in Looper it was a judicial power and indirectly private challenges, and over federal agencies, so in lengthy and official personal purgatories over an expansive view of state action, and in a mild row, and individual workers' rights over just a restrictive court doctrine. And even Rahimi, though it upheld the law, so was framed as a clarifying an individual right just to be free of violence within a historical tradition rather than just empowering government for its own sake. And, and basically, so like by this point, we decoded a 5 of the Supreme Court's tells bombshells. Like, so what's the bigger picture? One pattern emerges loud and clear, and the court is consistently just pulling power away from government bodies, like be there the agencies, state officials, or legislatures, and pushing it toward individuals with private entities, including corporations, and case after case. So the message was that the government doesn't get the final say here. Instead, you as an individual or a private company have more room to maneuver, and any overstep by bureaucrats or lawmakers will be checked. Think about it. An agency can't autofill the gaps of an ambiguous law anymore. So like Looper Bright took care of that. And the state can't command a social media company to hold speech. And the public official can't just accidentally turn their personal Facebook into a lawsuit magnet. Like LinkedIn had them free in that regard. And even the power of lower courts to extend those rights, so got a reality check when it threatens the safety of domestic violence victims, Rahimi. And in the workplace, employers, so whether private or government, can't hide behind the legal technicalities to dodge discrimination claims, like a Muldrow. And in each situation, the locus of power shifts a bit toward an individual rights or the private sector, and sometimes expanding what freedom means for those players. Like, is this freedom or chaos? You have to decide. But that reality depends on where you stand. And if you are someone who distrusts big government and red tape, the term probably feels like a liberation. And agencies are curtailed, states are muzzled, so when they overreach, and individuals can stand up in a court more easily. And it's vindication of a personal liberty and a check on authority. And on the other hand, so if you worry that corporations and individuals unleashed can harm the public interest, so you might see this as a creeping chaos. Like, who is going to reign in polluters like the tech giants and the workplace discriminators or reckless guns owners, if not the government? And every pullback of oversight could look like a loosening of a threats at and keep society safe and fair. And the truth is that it's a trade-off for every worker. So now empowered to sue. So there is an employer dealing with more litigation, and it's a very vivid, like for every domestic violence survivor protected. So there is gun rights, a purist for filming, and for every tech platform, so free to moderate. And there is a user so who feels silence. And for every agency, rule now is a jeopardy. So there is a business owner saying the final relief. And the Supreme Court isn't making those value judgments explicitly. So they're setting the ground rules, and we the people will sort out outcomes in the new legal landscape. And from now, one thing is certain, that these 5 cases may not have dominated headlines, but they quietly altered the legal fabric of everyday life. And the next time you scroll through social media, clock in at work, maybe drinking water, or maybe like you read about the domestic abuse arrest. So like, remember that the Supreme Court decision in 2024 are operating in the background, like shaping what's allowed and what's not. So we've decoded the signals for you. So like, the challenge now is to stay informed, because the real Supreme Court influence often lies in this less heralded rulings that just nonsense just to hit home. And whether you toss these challenges or fear them, so now you know that they are out there. And the court has reset the playing field, like empowering the individuals and the private entities, like reigning in governments and agencies, and freedom or chaos. Like, that's for each us to decide and to deal with. And in the coming years, at least now, you're on the secret shifts that most people missed, like decoder briefing complete. And if this decoded something for you, like, tap, so YouTube like shows it to people who need it, especially if you will subscribe, and I will break down like a next ruling before it blindsides your life.